So next bill on our agenda is House File 3483. Representative Feist. And while Representative Feist is coming up, her motion is going to be that House File 3483 be re-referred to the Public Safety, Finance, and Policy Committee. And welcome, Representative Feist, and please go ahead and present your bill.
Okay. Thank you, Madam Chair. Thank you, committee. So House File 3483 does two things. First, it requires a judicial warrant to enter private property, a domestic violence shelter, school property, or a school bus for purposes of civil immigration enforcement, codifying state and federal constitutional protections against unreasonable searches and seizures. It also codifies the findings of Esparza, a case that found that a judicial warrant is required in order for immigration detainers to be honored. I will address both of these in turn. First, again, this bill requires a judicial warrant to enter private property, and it is codifying state and federal constitutional protections against unreasonable searches and seizures. I personally find this very important to my constituents and our state. I'm aware of at least 5 incidents in my community where ICE agents have broken down doors to homes and entered premises without a judicial warrant. And I would like to read a statement from one of my community members about one of these incidents. In the most traumatic event of that day, 12 cars of agents broke down the door of a Hmong father who is in the legal process of obtaining a green card and who has no criminal record. Close to 50 people watched in horror as ICE broke the door down and went in with large automatic weapons to drag this man from his home in front of his family. Observers could do nothing to stop this violent home invasion as ICE pointed huge guns in the faces of neighbors who had gathered to film and honk their horns. The helplessness of watching the government terrorize innocent people with no fear of the people gathered who were literally filming their crimes is trauma that will haunt us for our years to come. The firepower it took to kidnap one unarmed person is ridiculous. The language in this bill requires a warrant to be signed by a neutral judge to ensure an independent check on law enforcement. Judges determine whether there is sufficient evidence to support probable cause and ensure the warrant scope is narrowly focused to permit only minimal incursions on people's rights. Judicial oversight functions as an essential check on government power. The second thing this bill does is it codifies the findings of Esparza, as I mentioned. That case found that in Minnesota, a judicial warrant is required in order for ICE detainers to be honored. In the Esparza decision, the court found that under Minnesota law enforcement agencies cannot hold someone who would otherwise be released from custody because the agency has received an immigration detainer. Federal regulations and subsequent court cases explicitly state that a detainer is a request, not a requirement. It is not mandatory. Minnesota state law does not authorize state and local officials to arrest an individual based on an immigration detainer. Further, Minnesota courts have found that meritless arrests constitute unreasonable search and seizure. From a policy standpoint, collaboration between local and federal law enforcement undermines trust between community and law enforcement, and that's bad for all of us. As the County Attorneys Association wrote earlier this term in a statement to the House on a related bill, quote, "Local participation in federal immigration enforcement undermines public safety by deterring members of immigrant communities from reporting crimes and participating in the prosecution of those crimes due to fear of immigration consequences," unquote. Notably, the worst of the worst are already in Department of Corrections custody. The DOC does honor ICE detainers, coordinating custody transfer, and I have a spreadsheet of all of those transfers if anyone has questions. Recent examples that were provided by the federal government of lack of collaboration between the DOC and the federal government do not align with the facts and have included names of people who were never in DOC custody, have no court records, and were released from ICE custody or from ICE, released to ICE decades ago. So this bill is not to address situations where people should be detained, are being detained, and are being handed over to ICE. This bill is to address racial profiling and harassment of people with no criminal record. To quote a recent federal court judge in a decision on behalf of a constituent of mine on the use of administrative warrants to detain people, quote, civics lessons to the government. Administrative warrants issued by the executive branch to itself do not pass probable cause muster. This is called the fox guarding the henhouse. The Constitution requires an independent judicial officer. And with that, I will turn it over to my expert.
All right, thank you, Representative Feist. So testifier is John Beeler. Welcome to the committee.
Thank you, Chair Liebling, Chair Scott, members of the committee. We're testifying today in support of HF 3483. Sections 1 through 4 of this bill should not be necessary. For nearly the entire history of our country and in nearly every area, warrants, as referred to in the Fourth Amendment, were understood to mean judicial warrants, those reviewed by an independent magistrate free from executive branch repercussions if they refuse to approve the warrant. The physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. It's from the recent Supreme Court opinion. If the home is seen as the chief evil, then it does not seem a great logical jump to imagine how the founders would also have seen warrantless entry by armed officers into a school bus or into a school.
Could you, Mr. Beeler, could you pull the mic just a bit closer? Thanks.
Yes, Chair. These administrative warrants did not even exist until the 1950s. The use and reliance on these self-governed and self-issued warrants is an affront to our constitutional protections of issuance by a judicial officer, probable cause, and particularity. We are also supportive of Section 5 of the bill, which prohibits detention solely on the basis of immigration warrants or immigration detainers. These detainers are currently unlawful under a Minnesota appellate court opinion in Esparza v. Nobles County, as Representative Feist discussed. A recent advisory opinion by the Attorney General confirmed this understanding while also highlighting the need for this codification because the Esparza decision is non-precedential. A detainer is an arrest. The requirements for a valid arrest are defined by the Minnesota Constitution and state statute. These arrests require warrants issued upon probable cause, or they need to meet the requirements for a warrantless arrest as defined in Minnesota statute. Codifying this understanding will save local governments and local law enforcement both litigation expenses and legal fees by clarifying their arrest and detention authority. And just to echo what Representative Feist said, this does not affect detainers while individuals remain in custody. So if an individual is sentenced to 30 days, an ICE detainer that requires transfer during those 30 days is lawful. This bill does not change that. It is the request to hold them for an additional 48 hours beyond that sentence that would be unlawful. That is currently unlawful, and this bill would also codify that. So just like that clarification. Thank you, Chair.
Thank you, Mr. Beeler. Are there member questions, discussion? Oh, I'm sorry, and I should ask, are there other members of the public who wish to testify on the bill? Okay, not seeing anyone. So any discussion from members? Representative Hudson.
Thank you, Madam Chair. Thank you, Representative Feist. I'm going to request a roll call first off. Can't support it. This would provide more protection against federal law enforcement than we currently enjoy against vandals and thieves. You're trespassing just by doing your job. It's that simple. I don't think we need to belabor the point. Thank you.
And there will be a roll call. Other discussion? Representative Curran.
Thank you, Chair. I won't belabor a point either. I really appreciate you taking this bill on, Representative Feist, and I agree it's awful that this is necessary, but I believe it is, and I'm happy to support it. Thank you.
Okay, well, maybe we'll get done early here today. I guess I would just say thank you for the bill, Representative Feist. I find it really astonishing that anybody would be against this bill because it's codifying existing law. It's writing constitutional protections into statute. And correct me if I'm wrong, Representative Feist or Mr. Beeler, but I don't think it's really changing anything. We should all be supporting the Constitution. We should all be outraged when, I mean, the Constitution is written, the Bill of Rights is written to protect individuals against government. And so the idea that, oh, they're just doing their jobs so they can do whatever because they're just doing their jobs, that is exactly why we have a Constitution. So it is really mind-boggling to me to hear an argument like that. And to me, this should be the easiest vote anybody takes all year. you're defending the Constitution, which we all, by the way, took an oath to do. So thank you for the bill. And with that, the clerk will call the roll. Oh, I'm sorry, did I miss somebody here?
Representative Feist.
Oh, Representative Feist wanted to, I'm sorry. Go ahead, did you want a final word?
Fiery speech, no, just kidding. I just wanted to say some concluding comments.
Please.
If that's okay, thank you. I appreciate your comments. I really do think that this is kind of a foundational bill that I would love for us all to support. The Fourth Amendment is at the heart of our constitutional protections. I've had really interesting conversations with Republican colleagues about kind of like where like Republican and DFL trust lies, and they're like, we don't trust the government. You trust the government, but we don't. I'm a former board member of the ACLU of Minnesota, so I don't really trust the government either. This is really important right now. The federal government is in the hands of the Republican Party, and maybe that makes you more comfortable with the underlying motives of their actions. But imagine that it's a Democratic president. Imagine that they're coming, for reasons that you do not support. We need to protect ourselves from overreach, and I believe that's what this legislation does. And lastly, just wanted to mention that, one of the reasons that we wrote the Declaration of Independence was specifically because of overbroad warrants and intrusion onto our homes. And so that's what this bill seeks to get at, and I would love your support. Thank you.
Thank you, Representative Feist. Sorry about that, almost not letting you have the final word. And I also need to renew the motion. I guess I was so carried away with the issue that I forgot that you need to renew the motion. So Representative Feist is renewing the motion that House File 3483 be re-referred to Public Safety, Finance, and Policy. So clerk will take the roll, and chair votes aye.
Chair Liebling, aye. Chair Scott? No. Chair Scott, no. Vice Chair Finke?
Aye.
Finke, aye. Vice Chair Hudson? Hudson, no. Representative Bliss? No. Bliss, no. Representative Curran?
Aye.
Curran, aye. Representative Duran? No. Duran, no. Representative Engen? No. Engen, no. Representative Feist?
Aye.
Feist, aye. Representative Frazier?
Aye.
Frazier, aye. Representative Mahmoud?
Aye.
Aye. Representative Moeller?
Aye.
Moeller, aye. Representative Steer?
No.
Steer, no. Representative Van Binsbergen? Sorry. No. Representative Van Binsbergen, no. 7-7.
So on a split vote, the bill does not advance. So thank you very much for your testimony. Thank you for the bill, Representative Feist. So with that, we are adjourned.